Okay, we're going to go ahead and get started just to be mindful of everybody's time. Good afternoon and welcome to today's Legal Grand Round. My name is Victoria Lancey and I'm the Education Coordinator with Michigan Center for Rural Health, and we facilitating today's program. I would like to welcome everybody to our Grand Round on Reasonable Accommodation in Unreasonable Legal Environment. It is brought to you by Michigan Center for Rural Health and Hall Render, Killian, Heath, and Lyman. Before we begin the program, just a couple of reminders. If you are logged into the webinar portion and have computer speakers, you can listen to the audio via your audio through your computer, or you can listen to the audio through the through the audio number provided through the webinar software. Handouts are located on our website, which is www.mcrh.msu.edu. Click on the education link on your left, scroll down, click on the Legal Grand Round, find today's date, and there you will see the attendance forms, the presentation, and an evaluation link. Please fill out an attendance form for a certificate of participation, and please fill out an evaluation as it helps us plan future Legal Grand Rounds. If you would like to ask a question during the program, please use the chat feature. If you would like to, otherwise, please wait to the end and we will open up all lines for a Q&A component at the end. Our presenter today indicates no conflict of interest, and the Planning Committee did not have any conflicts. There is no commercial support for this program. With that, I am pleased to introduce Jennifer Gonzalez, who is an attorney with Hall Render, Killian, Heath, and Lyman. And with that, I will turn it over to Jennifer Gonzalez. Thank you.
Thanks, Victoria. Good afternoon, everybody. As Victoria said, we are here today to talk about reasonable accommodation in an unreasonable legal environment. And I love talking about this issue because I get calls from clients every day just to talk about what to do, how to handle certain ADA situations. So I find it usually leaves people pretty happy to receive the information. Just by way of introduction, we're going to talk about a few of the legal changes because we can't really understand where we are going or what we have to do now if we don't understand what is different. With that, we'll talk about some of the EEOC enforcement efforts and the settlements that are making the news, as well as what an employer's duty is with respect to the accommodation of disabled employees. And we're going to talk about common pitfalls as they relate to employees taking a leave of absence or taking intermittent days off for disability-related conditions that are marked as attendance-related absences, as well as some recent cases and ways to reduce exposure. So what's different? Why is this such a big deal? The ADA has come kind of full circle since its implementation. When I first began my legal career, probably 13 years ago or so now, one of the first cases I worked on was an employee, the plaintiff was an employee who had one hand. His other hand had been amputated in his teens. And we got a judge to throw his case out, dismiss it in its entirety because we found, the judge found that he was not protected by the ADA. He testified during his deposition that he could perform any routine daily activities with a prosthetic device, and he wasn't substantially limited as compared to the rest of the population. Now we are seeing cases come completely the other way. We have bridge workers who are afraid of heights. We have pharmacists who are afraid of needles. We have lifeguards who are deaf. And all of these situations we have seen courts not only deny summary judgment, but push through suggesting that the employer needed to do more. So it's a very different world than what it was 10, 15, 20 years ago. What happened? The ADA was passed in 1990. It became effective shortly after that in 1992. And the focus at that point and all of the enforcement efforts were targeted towards whether or not the specific employee could meet the definition of what it meant to be disabled under the ADA. Cases were pretty employer friendly. They were focusing on trying to exclude people, saying they were not disabled. So we were looking a lot at the severity and duration of the impairment and how limiting the impairment was. And we were told by the Supreme Court that this was supposed to be a rigid standard. Not everyone is supposed to qualify for ADA protection. So when we were looking at our potential employees that we needed to accommodate, we also got to consider the positive effects of any medication or assistive devices that they were using. If we had an employee whose condition was controlled by medication, then we got to consider that employee and whether they were substantially limited in the, whether they were substantially limited in the major life activity as they were taking that medication or as they were using their assistive devices. So persons with epilepsy, diabetes, multiple sclerosis, depression, bipolar disorder, even amputees were found not to meet the definition of disability. And as I said, cases were pretty employer friendly. Now, that all changed in 2011. The ADA was amended in 2009, and even then, nobody was really catching on to what was different. The final regulations were implemented in May of 2011, and they didn't really change the underlying definition of disability. We were still talking about a physical or mental impairment that substantially limited one or more major life activities, or persons with a record of impairment or who were regarded as being impaired. So what was the big to-do? All of a sudden, we saw some big changes in terms of lowering of threshold for what it meant to be substantially limiting. Remember, the Supreme Court before had told us it was not really meant to be overly inclusive. It was supposed to be rigid, and now we've come full circle and we've been told it's not meant to be a demanding standard. It is not supposed to be unduly used as a tool to exclude individuals from the ADA's protections. And you don't even really need a significant or a severe restriction. We're also told that even short-term impairments may be a disability. We couple that with the list of expanded major life activities. In the legal community, we used to fight about whether people were substantially limited in the major life activity of working. And we did that because it was an easy thing for a plaintiff to allege that they were precluded from working. We don't have to fight about that anymore because now we've been told that the list of major life activities also includes the operation of all major bodily functions or organs. So when we're talking about someone who is impaired and substantially limited in a major life activity, if that physical or mental impairment now touches any of the operation of the major bodily functions or organs, so if it affects your skin, if it affects your circulatory system, if it affects your body's ability to process sugar, all of those now automatically qualify. Pretty much the only exception is ordinary eyeglasses. But otherwise, the determination of disability looks at the person's condition without the positive effects of that medication or without the positive effects of those assistive devices. So before, that person whose condition was controlled with medication, we now have to consider what it would look like if they didn't take the medication, even if the medication helps and brings them completely within the realm of being able to function day to day. If without the medication they would be impaired or limited as to the major population, then they're still considered within the ADA's protection. The same standard goes now for whether the person has a condition which is episodic or in remission. If it's something where if it wasn't in remission or if it was an active episode, if it's something that would substantially limit that person, then it's considered a disability all the time. We're also now told by Congress that we should make no mistake about it. The definition of disability should be construed in favor of broad coverage. Remember, this is very different than that U.S. Supreme Court rigid standard that we started with. And the question of whether an individual's impairment is a disability is not supposed to demand extensive analysis. So what this essentially did was blew our last 20 years of case law out of the water because we had spent the last 20 years litigating and narrowing the scope of who fell within the ADA's protection. Now we have a new focus, and that is what the employer did to reasonably accommodate that individual. And if they didn't do anything, why not? So I cannot take credit for this acronym, but I have seen it floating around on the internet, and essentially we should always consider anyone who is asking for help for some physical or mental impairment to be potentially disabled and always assess the need for accommodation. We've seen, in addition to those changes with the statute and the regs, we've seen a significant increase in the EEOC's enforcement effort. They are definitely stepping it up, and we've seen disability claims skyrocket since the ADA was implemented. They have a strategic enforcement plan that identifies a number of ADA issues as a national enforcement priority, which means that we are seeing the EEOC focus on these issues more and more, and they are not letting go. And we're going to see that with respect to some of the settlements that we've seen, or that we're going to talk about. So in the last 10 years, we've seen an increase of nearly double the amount of charges filing with respect to disability discrimination. And we've seen the settlement dollars recovered by the EEOC more than double. If you look, the last year reported was the year 2014. They're a little bit behind in their reporting, but they collected $95.5 million. And remember that this is just in claims settled. This doesn't account for things which proceeded to litigation and then were recovered there. So essentially now we are left with a standard where it's considered discriminatory under the ADA to not provide a reasonable accommodation unless it would create an undue hardship for the employer or it would result in a direct threat. What are we talking about here? Essentially, we need to consider every single request for a reasonable accommodation, and we need to look at whether or not the accommodation is necessary. If it is, whether it would be effective for all parties involved, and if it is effective, whether providing the reasonable accommodation would impose an undue hardship or a direct threat on the employer. Now, I hear a lot of questions from employer about cost and what it means to create an undue hardship. There is no hard, set, rigid standard, nothing black and white, but I can tell you that unless the accommodation is going to cost about $500,000 or so, cost alone is not going to be determinative. What we see the focus on from the EEOC is cost coupled with the impact on business operations. It will always be an undue hardship to not be able to conduct business. The employer, thankfully, still gets to determine what business needs to be done and, generally speaking, the means about which they need to accomplish that. So what we do is we look at the nature and the cost of the requested accommodation, and we look at the resources and the circumstances, and we compare that with the cost and the difficulty of providing that accommodation. In terms of direct threat, healthcare employers have a little bit of an added benefit here because patient safety is always a priority, and it can't sit in the background second to an employee's rights with respect to reasonable accommodation. So there are a number of healthcare clients that we service where we find that assessing the risk of allowing the person with a lifting restriction to continue to work lifting patients would be problematic, and we create a direct threat to safety of the patient involved. That is not always the case, but it definitely is a great argument in the healthcare world. So what we're looking at when we're talking about direct threat is the significant risk of substantial harm to the health or safety of the individual who's requesting the accommodation or others. And it can't just be any risk of substantial harm. It has to be a risk that cannot be eliminated or reduced by a reasonable accommodation. So if there is, say, with respect to the lifting restriction, if we have a nurse with a lifting restriction and the employer says, well, it would be a risk to patient safety to allow this nurse to continue working with a lifting restriction because she can't safely lift patients. We need to go through that analysis and that assessment of whether there is anything else we can do which would accommodate that nurse that would still meet the nurse's needs with respect to the restriction and also eliminate or reduce the risk to patient safety. So can we do something else with respect to lifting? Are there other people available to help lift? Is there a way that we can transfer her to a unit where less lifting is done? Is there a turn team that can be used to come in and help with patient lifting? Can that function be assisted by PCTs? You know, we need to kind of go through that analysis to see if we can eliminate that risk before just moving into, well, it's a threat, we can't do it. If we cannot eliminate or reduce that risk to an acceptable level, then that person, if the requested accommodation would provide a direct threat either to that individual requesting or to anyone else, that person would be outside of the protections of the ADA. So as I said, some of the biggest accommodation challenges we're seeing come up with respect to leaves of absence and employees who need those regular, what otherwise would be referred to as intermittent FMLA days off, but once they've exhausted intermittent FMLA. What do we do with that person who has a migraine? We know that migraines are probably going to be considered a disability under the ADA now. So what do we do when FMLA is exhausted and that person continues to need 1 or 2 days off a month? How do we handle those? The EEOC has taken a very firm position on this with respect to enforcement. And they have said point blank that an employer may not apply a no-fault leave policy under which employees are automatically terminated after they've been on leave for a certain period of time to an employee with a disability who needs leave beyond that set period. Now, this is a pretty big departure from what we have seen in years past, because up until the ADA was revised, we had counseled and employers had very good luck with policies for leaves of absence that had a pretty defined end date. If you gave employees 3 months for a leave and they were unable to return to work at that point in time, we said, okay, we're going to find someone that can do the job. Now we're hearing that actually that the end of that leave period, once it comes and goes, we still need to consider whether it makes sense to continue that leave. We cannot proceed with an automatic termination at that point in time. We also hear from the EEOC that an employee with a disability who is granted leave as a reasonable accommodation is entitled to return to his or her same position. Now, this also is something, we have a line of cases which developed previously where once the FMLA period exhausted and that individual was unable to return, they could be replaced. That position could be filled. We hear from the EEOC now that if you're going to extend that leave and allow that leave as a reasonable accommodation, it's hardly a reasonable accommodation if the person doesn't have a job to return to upon the conclusion of their leave. Now, does that mean we always need to leave this position open from now until eternity? No, we still get that undue hardship defense, but we need to focus on whether or not it actually is creating an undue hardship, and we need to focus on documenting that hardship so that we can move forward. Because again, if we're not holding that position open, we need to be able to explain why. Now, even in those circumstances where we are able to document an undue hardship, we can't leave this position open. We absolutely need someone in this position. The EEOC says that's fine. Then you need to consider, employer, whether or not you have a vacant equivalent position that you could transfer the employee to, reassign them to that position, and then they can finish their leave for the remainder of the leave period and then be returned to the new position. I get a lot of people saying, for real? What are we supposed to do? How on earth is this even feasible when we have, say, more than 20 employees who are taking leave? That's a lot to manage. How do we make it happen? How do we get this process documented? Where do we go from here? They are absolutely serious, is the answer to the are they serious question. We have seen that from the settlements. We have seen very, very high dollar settlements. And if you look at the timing of these settlements, they're pretty ruthless. Remember that the ADA was modified in 2009. We got the new regulations in 2011. Even before that, the EEOC starts going gung-ho and comes out with a $6.2 million settlement against Sears and Roebuck with respect to an inflexible leave policy that automatically terminated people after they had exhausted available leave options. Shortly after the regs came out, we saw another $3.2 million settlement, again with respect to an overly rigid and illegal disability policy. That case is actually still in the news, and there was another almost $500,000 in penalties and fines this March because the employer was apparently violating the consent decree. They had agreed to reasonably accommodate employees seeking to return from disability leave, and the EEOC established that they were not doing what they had promised. The biggest and most notable, I think, that kind of turned a lot of heads was, again, shortly after the regulations were revised and issued, and it came out against Verizon, and Verizon Wireless had agreed to pay $20 million to settle a class claim involving employees. What, you asked, did they do that was so bad? They had a no-fault attendance policy, much like many employers and workplaces across America. And when employees were absent, they accrued a certain number of points that were chargeable absences. And once they accumulated that designated number of chargeable absences, they received discipline. And those disciplines could accumulate and ultimately result in termination. And the EEOC said that, no, you, Verizon, need to be considering if the employee is out on an absence related to a disability, rather than penalizing them, you need to look at whether or not there's a reasonable accommodation which could be made, and is there something which can be done? And one of those things is a lessening of the attendance policy, a modification of that requirement, if it's not going to result in an undue hardship. So the fact that there was this automatic process in place with respect to the no-fault attendance policy was a huge problem for the EEOC. And this decision now, or this Verizon's decision to settle this matter for $20 million, has kind of created a huge problem for employers everywhere who are looking to enforce very similar policies. Because at the end of the day, we need to get some method in place to be able to enforce some sort of attendance requirements and get people to come to work. We did at that point see a little bit of a break after that. That was kind of a grand finale for a while. After that, we saw the EEOC embark upon an educational campaign and went on a cross-country tour, setting up conferences and educational sessions to let employers know, look, the rules are changing. They have changed, and we need different attempts at reasonable accommodation than we're focused on in the past. And we need to be able to see some documented efforts that you are working through these issues on an individualized basis. So we had a little bit of a hiatus there, and then we started to see them cropping up again. And we saw another health-related system agree to a six-figure settlement with respect to a decision to not extend a 4-week disability leave. And if you think about that, when you have a smaller sized facility and you have an employee who's been out for a month and you don't have a policy which provides for longer than that, it may be very difficult to extend that leave. It may result in an undue hardship to hold that position open. At some point, we still need to be able to treat patients. So that matter focused on the fact that there was an automatic denial beyond that 4-week extension because they had already granted the 4-week extension without regard to what impact it had on business operations. We saw another $1.35 million settlement come out, again, another healthcare system, with respect to a fixed leave policy and failure to consider leave beyond that fixed period. We'll talk about some changes that you can make to your policies a little bit later, but to the extent that you have one of these fixed periods in your policy, I would recommend that you talk with someone to see what you can do to build in some flexibility and soften the language. Still leave that general provision that, normally our hospital or our facility deems 3 months or 4 weeks or whatever it is to be a reasonable amount of leave, but employees that require accommodation, make contact and put in a point of contact so that we at least have that option to point to. There's also been a lot of focus recently in terms of what to do with that transfer. We've heard the EEOC talk about transfer to a vacant position as a reasonable accommodation, and there were a lot of employers who were trying to use that as an application process and considering that transferred employee along with all of the other applicants to select the best qualified candidate for their position. We've been told that that's not okay either. When we're talking about transfer to a vacant position, we now have decisions from, I believe, all of the circuits which say we're talking about transfer. We're not talking about the right to compete for a job. And United Airlines recently agreed to pay $1 million settlement because it was going through this process where when they replaced a position that was previously held by an employee who was disabled and on leave, rather than transferring that employee, they had them compete for that new position. We see another recent settlement out of California, another 6-figure settlement where the employer, again, a hospital, failed to extend the leave. They had a 6-month policy limit, and they said the employee has been off for 6 months, we're going to replace her, and we can't do this anymore, and did not consider whether or not it made sense to allow the individual to take additional time off, and paid $300,000 as a result of that. We also see the lawsuits keep coming. These are just a few that have occurred in the last 3 months or so. There is a suit that's been filed against Dunkin' Donuts for terminating a manager suffering from breast cancer instead of providing leave as a reasonable accommodation. Another suit against Walmart for revoking a prior scheduling accommodation that had been previously offered to the employee. And another suit against Oklahoma Concrete for terminating an employee who requested additional time off for cancer treatment. So just know that when these requests are coming in, we always need to be evaluating. What we do know now is that that additional leave time and the job protection beyond FMLA and beyond your own policy limit can be a reasonable accommodation. It's not always, but it can be. And those decisions need to be made on a case-by-case basis. So there needs to be a process in place for evaluating those requests and documenting the hardships. Because as we've been told numerous times now by the EEOC, leave from work is not a reasonable accommodation where the employee does not have a job to return to at the conclusion of that leave. And if we have an employee with a disability who needs additional unpaid leave as a reasonable accommodation, the EEOC takes the position that the employer must modify its no-fault leave policy to provide the additional time, unless another effective accommodation exists, or it would create an undue hardship. Now, a lot of people are probably sitting around the table shaking their heads. I understand this reaction. It's unfortunately not really an option at this point. You know, the risks of noncompliance are extremely great. Jury trials are ridiculously expensive. They come with penalties of back pay, lost benefits, compensatory damages, punitive damages, attorney's fees for the other side, in addition to the employer's attorney's fees. So what I get every day is, what am I supposed to do? How on earth am I supposed to enforce my leave of absence policy? What am I supposed to do about employee attendance when every other day that person with the migraine is calling in? And the best that we can say at this point is communicate and document and use that interactive process to your advantage. We are seeing a lot of decisions now coming out from the courts, and we're going to talk about some of the details of those as well, about how it is not reasonable for an employee to just show up whenever they want without notice. But we do need to make sure that we're communicating with that employee about what options are available and documenting our efforts, because at the end of the day, the documentation about how hard we tried and what efforts we made is probably going to be your golden ticket with respect to a defense. Consider there are, as daunting as it is, there are a number of benefits to the interactive process. If we can work through the process and actually find an accommodation which works for everyone, it gets the job done. There is no job loss, there's no turnover, there's no retraining. We've got an experienced worker who's probably more dedicated now than previously. If we do fail to reach an accommodation, but we can still demonstrate that we, in good faith, worked with this employee to work through the process and try and identify reasonable accommodations and make those offers, at the end of the day, if there is a lawsuit, that would eliminate any punitive damages and compensatory damages. So it would significantly reduce liability. So I've used this phrase interactive process. There is not any one definition of interactive process in the statute or the regulations, other than to know that cases talk about the critical need for employers to engage in some form of interactive discussion with employees who are requesting accommodation. So these are kind of the 4 steps that we would recommend going through when you receive that request for accommodation every single time, so that we can go through objectively, come up with whether or not we have any options, get all those options on the table, talk to the employee about what options might work the best, if those don't work, why they won't work, and move forward documenting our efforts so that we are best situated to defend any sort of disability claim. And those involve, number 1, analyzing the job functions, 2, looking at the precise job limitations that the person has. 3, looking at potential accommodations. And then 4, trying to select an effective accommodation. So when we talk about analyzing job functions, we're looking at an individualized assessment of that particular person's job. I'm sure everyone can sit there and say, well, we have a job description. And I have talked with more clients than I can count on my fingers and toes that admit fully they have a job description, but it hasn't been updated since, say, the mid-90s. Just because we have a job description doesn't necessarily mean that it's an accurate description with respect to that individual. So let's look at the job description, start there, but have the employee provide input. Do you do these things on a daily basis? Do you not? Is there anything in this job description that should come out? Is there anything not in this job description that you do every day? What we need to do is get some input from the employee, and we need to understand what exactly that person needs to be doing every day. What did we hire them to do? What do we need them to be doing for business to be working? And we get that employee to buy in on that function. Yes, every day I need to lift patients. Yes, every day I need to show up for work at 8 a.m. That's my assigned shift. It's very critical that I be here at 8 a.m. because I do A, B, and C, and I'm the only one qualified to do A, B, and C. Let's get that information documented so that we know what our universe is that we need to get done. Then we need to look at the individual's precise limitations. Do they have a lifting restriction? Do they have a scheduling restriction? Do they have a stable impairment, or do they have more of an unpredictable condition where we don't really know when they're going to be able to work or how long? We've got someone calling in at all hours, or we've got someone coming to work but then needing to leave early. Let's just figure out what we're looking at that we need to accommodate. And it's very critical that we get that documentation from the individual's healthcare provider, because especially once we've exhausted FMLA, we no longer have that certification procedure. We have the ability to continue documenting what the limitations are so that we can, from a business perspective, accommodate them. We are not entitled to things such as diagnoses or what the nitty-gritty details of the person's prognosis are, or even necessarily the name of their condition or the name of their disability. But we are entitled to information about what job functions they can do and what job functions they need assistance with. Frequently, we will provide a copy of the job description to the individual to give to his or her healthcare provider to address which of these functions this person can do without problem, which ones require accommodation, and which ones can't be accommodated. At that point, we got to sit down with the employee, and we also will get some input from the manager separately about what possible ideas we could use to make this all work. Maybe there's nothing, but we definitely need to sit down and have that conversation, document what's discussed with that employee. Once we come up with a list, the employee may frequently have several ideas to offer, and when you present those to the manager may be able to shoot all of them down and say, no, that actually won't work. It will totally prohibit us from conducting business. It would compromise patient safety. We listen to those ideas too. We talk with the manager about additional ideas, take those back to the employee, make it an interactive process so that if ever you're being deposed one day, you can sit there during your deposition and say, yes, absolutely, I consulted with the employee, I consulted with the manager, these were all of the ideas that we discussed. Well, why didn't you discuss anything else? None of us at the time could think of anything else. We looked at all of the ideas that we could come up with. We've consulted outside resources, and none of those options would work. At that point, we asked the employee, is there anything else you can think of that we could do which would enable you to do this job? And they said no. So at that point, your defense is pretty well documented. But we need to make sure that that is written down somewhere, because if there's an informal process just between the employee and the manager, hey, I need some assistance with this, can I just work a 9 o'clock shift instead of an 8 o'clock shift? And the manager says yes. Then lo and behold, when the employee files a lawsuit 2 years later saying that we failed to accommodate their disability because we didn't offer them, a midnight shift, or we didn't offer them a PM shift, we don't have that documentation about what was requested. So it's really imperative that managers be familiar with this process and be adequately trained so that they know to field these questions from employees to someone who has the ability to document them. And then the final step, as I said, let's find whether something works. If nothing will work, then let's make sure we document that. While we consider the employee's preference, we don't have to give the employee their preference just because that's what they asked for. If there's more than one effective accommodation, we can have the ability, it's the employer's choice. We can choose the least expensive one. We can choose the one that we think works best for us. Now, if there are several accommodation options available and we choose one that the employee is adamantly against, we best be able to explain why we've selected this one as opposed to the one of the employee's choosing. Otherwise, it may be viewed as retaliatory. Talk about whether it makes sense to do something on a trial basis. You know, a lot of times we're not sure if something's going to work, but if we give it a try and then we can document that it hasn't worked or that it won't work, we get a lot further in terms of defending a claim than if we had never tried at all. If we can't agree on an option, then the employer may select any effective option that we have identified. It doesn't have to be the best one necessarily. Just remembering that if there is an employee buy-in into the system or into the decision, it's more likely to work. And if we cannot find an accommodation which works, and we've kind of gone through all of them, then we get the employee to agree that there is nothing else that we can do which would enable him or her to do this job. And then we look at possibly transferring the person to a vacant position or possibly extending the leave unless those situations would create an undue hardship. It's very important to consult both the employee and the manager. That should go without saying, but I have had a number of conversations with HR consultants and managers over the years where they say, well, you know, the employee requested the accommodation and then I talked to the manager and the manager said it didn't work. Well, did you talk with the employee after that point? Well, no, because the manager said it didn't work. You never want to have to testify, no, you've never actually had a conversation with the employee about this. It's hard to say that it's an interactive process if we can't show and prove that we actually had interaction with that employee. In terms of documenting your efforts, we've included in the materials a sample reasonable accommodation worksheet, which we have had several clients find success with using. And you'll see that it analyzes or it includes a brief outline of those 4 steps that we've talked about: analyzing the functions, determining the limitations, identifying the potential accommodations, and selecting the most appropriate one. And just think for a minute about how valuable a document such as this could be if you've got an employee who's making a claim that you failed to accommodate their disability, and you can show in writing where the employee signed off that, yes, this accurately describes your job functions. You have to be able to type 300 words a minute, otherwise you're not going to meet our productivity requirements. You have to be able to lift 75 pounds. You've told us you can't. There's nothing we can give you that would enable you to do that. You've told us on this sheet, we've documented what you've said, and you said there was nothing else that we could do. So when you're suing us later, because there's nothing else that we could do then, there's still nothing else that we could do. We also need to go through a process with respect to each and every request for leave or request for time off. And I encourage you to kind of begin this questioning process with managers as they're calling HR to say, look, this employee's been off, 3 times this month, I can't do this anymore. A lot of the discussion we have that focuses on absences when people call me on the phone has to do with the difference now between what's happening now and what happened during the FMLA period. Because if you remember and think about it for a second, FMLA can be used intermittently. If an employee uses his or her 12 weeks of intermittent FMLA leave at the rate of 1 day a week, he or she will never run out. It can go on and perpetuate into eternity as long as that doctor keeps signing off on the fact that this person is going to have a migraine of approximately 1 day long once a week. So we get to these questions when somebody has taken a chunk of time, and has otherwise used that leave. But if under FMLA we can get someone absent 4 times a month and we have to fix it, we have to do it, we don't get an undue hardship defense under the FMLA. The question that we see the EEOC focusing on is, why now? Why could you do it if this person has used intermittent FMLA for the last 3 years and been absent once a week? Now that they're out of FMLA, why can't you do it now? What's the hardship? You clearly have still operated your business for the last 3 years. You're clearly still treating patients safely. There has been nothing bad that has happened because this person has been out once a week. So why, employer, why can't you do this anymore? So some of the questions that we focus on are kind of targeted at getting to that information. You know, first off, we look at whether or not the individual has actually provided documentation that supports the medical need for the time off. There's a lot of situations where the employee will ask for the time and just assume that because before it's been granted, it will be granted in the future. If we don't have that updated medical documentation, if the FMLA period ended and we have had no more certifications for the last 3 years, by all means, let's get documentation to that physician to confirm that this employee still needs the time off every week. Do we believe that information from the doctor? Is there any report from other employees that this person is, say, you know, going to the beach, playing volleyball on his or her days off? Let's find out whether or not some sort of independent medical exam might be worth pursuing. How long has the person been employed? If we're talking about a new employee, it doesn't eliminate your need to accommodate or your duty to accommodate, but it does potentially play into the equation, because if this person was just hired and we've had a vacant position for some time and have a real void for someone doing this job, it's a little bit easier to fill a position then than if we have had other people kind of filling in that backlog. How much leave is available under your normal leave and attendance policy? I've had several clients who have had very generous leave and attendance policies, to the point where a person could be out for up to a year. And so if you have a leave of absence policy which permits employees to take an unpaid leave of absence for up to a year, and then someone presents you with a note from the doctor that says, I need 8 months of time, it's pretty difficult to argue that it would be an undue hardship to provide that leave when our leave policy, as it's written, already provides more than that. How much time has the employee already taken? You know, sometimes we're looking at this from the 3rd, 4th, 5th request for extension. How have your business operations been impacted to date? And that's where it becomes critical to document what we're doing to backfill that workflow during the employee's absence, even during the FMLA period. Not in a way that makes it appear retaliatory for having taken or exercised rights under the FMLA, but just from the perspective of, yes, we have been able to function, but we're paying someone overtime every week to do this job. Or, you know, yes, we're falling behind because we don't have enough bodies to do this job and we can't replace this body yet. So we can do this for maybe 3 or 4 months before it's going to become a problem. But we are going to need to consider how that work has been completed during the employee's absence to date. And we look at whether or not it would be reasonable to continue using the same method of coverage for a new request for an extension. Because again, if we've been doing the same thing for the last 3 years, we need to decide, or at least ask the question, why? Why now is it different? Is it just because it's the 3rd time the person's asked for more time off? How is it going to impact business operations? How is it going to impact expenses? What happens if we approve the leave? What happens if we don't approve the leave? It's hard to argue that if someone comes in and says, look, I was expected back at work October 1st, I'm actually not going to be able to return to work October 1st. I'm going to need off until October 21st, but then I will be able to return to work. It's another 3 weeks. It's definitely a problem, but chances are we're not going to be able to post, fill, and train someone to do that job in the next 3 weeks, so it wouldn't get done anyway, even if we terminated their employment today. So under those circumstances, it may make sense to continue with that leave and give them the additional 3 weeks. We look at what the employee's essential job functions are and how those are going to get completed, how they're not going to get completed if we don't approve or if we do approve. Is time off the only effective accommodation? We a lot of times get caught up in the employee's request for an extension, and once they're out of FMLA time, remember that continued leave is not the only option. We can transfer them to a vacant position, and sometimes that's an equivalent position, sometimes that's a lower paying position, but if we have the ability to bring them back to work, then a lot of times people might have a little bit of a miraculous recovery when they learn that they're actually going to have to come in anyway and maybe do a lower paying job. We need to look at whether attendance is integral to the employee's position. Most of the time in healthcare it's going to be, because it's going to be hard to provide, say, nursing or tech assistants or physician assistants to patients, providing patient care without actually being physically present. But if this is a telehealth situation, or if this is a medical biller, can the employee do this work from home? Have they given us an estimated return to work date? And we need to focus on with them, if the time off is granted, are they likely to return to work in the reasonable future? We see a big shift or a big difference between my next appointment date, my next evaluation date, versus this is my return to work date. So we are entitled to ask them when they believe they can return to work. Not necessarily without restrictions. Remind them that if there's anything we can do which would enable them to do their job, we're happy to do it. But we need to know when they expect to return for our planning purposes. Again, consider whether or not there's a vacant position for which the individual is qualified that would enable them to continue working. And ask the employee, what do you think is reasonable? What do you want us to do? At some point, we need to get this work done. How do you propose we get this done? So with those questions, generally comes a lot more information, and a lot of it then can be boiled down in conversations with the employees and managers that just helps getting everybody on the same page. Let's talk about it. Let's talk about what might be reasonable, what might not be reasonable, and why. And if everybody's in agreement with that and we document it, then if we do have to get into a termination situation, it's not a surprise to the employee. We've documented our accommodation efforts, and typically it's after a point in time where there was a conversation where the employee said, you're right, I can't come back to work. There is nothing else that you can do which will enable me to return. And I can't tell you when I'm coming back. And at that point, we know that indefinite leave is not reasonable, and we're much better positioned. I have included some summaries of some recent cases for you, just to kind of go through a few highlights. There are, as I said, some cases which show that there is some hope. An example comes out of the DC circuit. There was a plaintiff who suffered from the stereotypical migraine, as well as chronic pain, sleep apnea, hypothyroidism, depression, requested an accommodation to increase her productivity. She wanted to work from home. She wanted to adjust her work schedule, make up time on the weekends. Now look at the bottom line here. Plaintiff missed 50% of her work hours between January and July, and 40% of her work hours from July through October. She's only working half time. So anytime you have a manager saying, well, you know, they missed 50% of their shifts last month, remember that when we're getting these favorable cases, these cases that say people can't just show up whenever they want, it's only after we have tried for a very long time. We have tried for 6 months. We have tried for 9 months in this case to make this work. And over a 9-month period, this person is only reporting to work half of the time. The court found that the repeated absences and the deleterious effect they had on her team at the Coast Guard served as legitimate reasons for terminating that are distinct from her disability. And in the end, plaintiff's requested work accommodation was an unpredictable, flexible schedule that allowed her to come into work whenever she could make it. This was unreasonable as a matter of law. Making it to work regularly is an essential function of the job that plaintiff could not muster even with the requested accommodation. So even if she was asking to work from home, even if she was asking for a schedule change, the employer had documented in that case over a 9-month period, she was still only working 50% of the time. We saw a very similar holding out of the Oklahoma Western District Court, and we saw that from March through November, the plaintiff took off work to attend 7 different doctor's appointments and either left early or was off entirely on another 16 occasions because she was sick or caring for a sick family member. At that point in time, she worked at a clinic and her attendance was critical. She needed to be there to provide that care. And the court found that because of the plaintiff's excessive absences, there was no genuine issue of material fact that she was not qualified for her position. That's the kind of language that we want to be looking for. So remember that we need to be able to demonstrate essentially that there's no genuine issue of material fact that this person's not qualified. We've tried everything to get them qualified. We just can't get there. Another case out of the District of Nevada, there was an employee who spent the majority of the year 2010 out on leave, took time off again in October for 2 surgeries. The available leave ran out. The employer provided an additional month of unpaid leave, and then the employee was eventually terminated after he failed to return to work on November 15th and failed to respond to the return demand. So it was key that the employer sent him a notice that said, your time is up. You know, unless you provide us with additional documentation, we expect you back at work. The employee didn't respond. And the court there provided some helpful language in terms of determining what's reasonable and what's not in terms of an extension or a leave. And they said, as one trial court persuasively summarized, there are 2 limits on the bounds of reasonableness for leaves of absence. The first limit is clear. The employee must provide the employer an estimated date when she can resume her essential duties. The second is durational. A leave request must assure an employer that an employee can perform the essential functions of her position in the near future. Now, does that mean that they have to provide them within the near future? No, but we need some representation by the employee that the leave is going to be able to enable that person to come back. The court then went through, look, this person was undisputably provided with several leaves prior to October. Even though all FMLA leave was exhausted in July, the employer granted another 30 days of leave and then provided more than a month after that to recover from the October surgery. And then under those circumstances, the plaintiff could not establish denial of any reasonable accommodation where he had not been able to provide any expected return to work date. Now, those are all the good news. The bad news is we still have a number of cases that are coming out that are swinging the other way. So they are still very factually intensive. A case out of the Western District of Washington, the plaintiff was granted 12 weeks of FMLA and then an additional 2 30 days extension. So they were out an additional 2 months beyond the 12 weeks, 5 months of absence. The physician said, treatment's not going well. It could continue indefinitely. The employer heard those magic words, indefinitely, and said, we're done, terminated. Now, the court said, while an indefinite leave is not reasonable, the employer did not have any discussion with the employee regarding the need for additional time off. The employee should not have been terminated where she had a scheduled return to work date 5 months later. So once the claim had been filed, 5 months after that point in time where the employer had terminated her employment, the employee was cleared to return to work. The court looked at that and said, well, clearly she wasn't indefinitely off. There was a definite period. And if the employer had actually engaged in that interactive process, had the conversation with the employee, they might have found out that she might be returning to work within a finite time period. So that case, summary judgment was denied. We saw another case out of the Western District of Washington just a little bit earlier. The plaintiff suffered, again, chronic migraines, asked to work flexible hours, partial days from home, and the court said, well, maintaining a regular and predictable work schedule may be an essential function of her job. There's a genuine dispute about whether she could perform this essential function had she been provided with a reasonable accommodation of flexible or partial days that had been successful in the past. So this was a case where the employee had previously been permitted to work from home. The policy at the workplace changed. There were concerns that employees working from home were not getting the job done. So what they did was said, no one's working from home anymore. And at that point, the plaintiff said, I can't do my job. I need this as a reasonable accommodation. And the court denied summary judgment because the employer had not been able to show that it would be unreasonable to allow her to continue that, even though there was a change in the workplace policy. Another recent case out of the Northern District of Illinois, there was a plaintiff who was working as a part-time scheduling registrar. She requested a change to registry status, which under that health system was kind of like a PRN, or In the alternative, she asked for a month of personal leave so that she could be available for last-minute medical appointments so she could get cancer testing done. And the court said that there are issues of fact as to whether granting this request would have imposed an undue hardship on the employer. At the time she requested her month of personal leave, they did not dispute that the patient access department was extremely short-staffed, especially on the midnight shift where plaintiff was working. And while being short-staffed could certainly justify a denial of that leave request, there's evidence in the record, and the court found that a jury could conclude that the staff constraints were not the consideration. In this case, the Human Resources Department had initially approved the request. And when I say the Human Resources Department, the Human Resources Secretary sitting at the desk had accepted the request from the plaintiff and told her, "Not a problem, we'll take care of it." She did not have the power to approve that request. She did not have the authority to designate that leave as approved or not approved. Once the leave request was reviewed, the Human Resources Department decided, no, we actually cannot grant this request. The court looked at that and said, well, employer, you should not have been inconsistent in your conversations with this employee. She had the impression that her leave had been approved. She thought it was, and you never explained satisfactorily why you had to revoke it. So at that point, once the leave had not been approved, the employee's employment was terminated, and the court again, in this case, denied summary judgment to the employer. We had another case come out of the District of Nevada. This one is also kind of telling because we've got a plaintiff who's off for knee surgery. Now, knee pain in the past is something where we would look at as maybe not so much qualifying as a disability. It's not necessarily chronic and ongoing. If there is surgery involved, presumably once the employee gets his or her surgery, they would be improved and able to return to the workplace. In this case, we see the court say knee pain qualifies as a physical impairment. So to the extent that the employer is arguing that the plaintiff's alleged disability was transitory and minor, that's a question of fact for the jury. This kind of drives home the point that, look, we're not focused on whether or not things are a disability. We should always presume that a jury would find that they are. The court then went on to say that a leave of absence for medical treatment may be a reasonable accommodation under the ADA, where it would allow the employee to, upon his return, perform the essential functions of the job. And we have the court saying that the ADA does not require an employee to show that a leave is certain or even likely to be successful to prove that it's a reasonable accommodation. As long as a reasonable accommodation available to the employer could have plausibly enabled a handicapped employee to adequately perform his job, an employer is liable for failing to attempt that accommodation. So we look at this language and we contrast it with the language that we saw in the earlier district court decision, which said it has to be reasonably feasible for the employee to return, reasonably plausible. And this says it just has to maybe show that the person could come back and perform the job. And if the employer doesn't try, they are liable for failing to attempt that. We had the plaintiff in this case admit he couldn't perform any job other than talking on the phone while lying with his leg elevated for 3 months after his surgery. He couldn't return to a sales job for at least 3 months, possibly 6 months, which could have placed the employer in a potentially difficult position of granting an indefinite leave. But again, we see the employer's failure to engage in the mandatory interactive process with plaintiff renders it impossible to assess the reasonableness of the plaintiff's desired medical leave. Every time we need to be documenting that conversation. In this case, the employee, once he told his HR department that he needed 3 or 6 months off and couldn't do anything except lie there with his leg up in the air, the HR department said, I'm sorry, we need someone who's actually engaged in sales because that's your job, and terminated his employment. So the court found that that was, again, not a situation that was appropriate to grant summary judgment, denied summary judgment, saying that the employer failed to engage in the interactive process. This is the question for the jury as to whether or not this person was denied an accommodation. So where does that leave us? I would encourage you to review any existing policies, as I previously mentioned. Talk with your attorneys. If you need additional assistance, you can certainly reach out to me, but work with someone to build in some flexibility for reasonable accommodation of disability-related absences. You do not want to find yourself in a position where you have to hand your policy over to the EEOC or to a court, which says point blank, after 6 months or after 3 months or after 9 months, however long it is, your employment will be presumed terminated. You do not want to have an automatic termination situation. Continue to track employee absences for the purposes of determining the effect on your business so that you can work to document that undue hardship. Document what's happening, how you're getting the work done, why it's not working, because then at the end of that FMLA period, you do have the ability to talk with the employee during the interactive process and say, well, this is how we've been doing it for the last 12 weeks. This is how we've been doing it for the last 12 months. This is not working for us because, put that back onto the employee and say, what can you do? What can we do which would enable you to do more of your job? Continue that interactive process to determine if there's anything that you can do that would make attendance more regular. Maybe if we have an employee who's chronically late, changing the schedule would enable him or her to arrive to work on time. If there are frequent disability-related absences that are causing business disruption, look at transferring them to a vacant position or maybe granting a continuous leave of absence. Document those hardships, focus on the individualized inquiry. And because it's such an individualized inquiry, make sure that you're reviewing for any disparate impact, because it's maybe not going to be readily apparent that in one situation it works, in the other situation it doesn't. But if it works in the situation where you have a Caucasian male employee under the age of 40, and it doesn't work when you have an African-American female employee over the age of 40, you can be facing a discrimination claim too. Consider whether an independent medical evaluation would be helpful, especially if you have a case of abuse, and be patient, because what we have seen from the courts is that this is changing daily and there will be additional changes coming. With that, I will open it up to questions, and I think otherwise we're set.
We'll now open the line for questions and comments. I will unmute all of the lines now, so just be mindful that we can hear you. And all the lines now are unmuted, and you can feel free to use the chat feature within the webinar software. So you can type your question either into me or Jennifer, and we will answer them that way, or you can go ahead and ask your question.
My name is Rose Staklovich from Sterling Area Health Center. Hi. We have a new accommodation request that came up. The employee is bipolar, ADHD, has anxiety, asking for understanding for her forgetfulness, help with reminders, and variation to her workload. What are your thoughts on that? Any ideas?
I think you are probably better situated than most. We never have to vary the productivity requirements. So if you have, depending on what her job is to do, but if you have, say, a certain number of patients that people are expected to see, she is expected to see a similar amount. Now, if it would be helpful for her to maybe work a shorter shift and adjust that productivity, so instead of seeing 12 patients a day, she sees 6, but she does it in half the time, that's possibly something to consider. But we don't need to say, okay, you get to do less work for the same pay when everyone else does higher work or double work for the same pay. In terms of the forgetfulness and the reminders, I would sit down and talk with her about what she's thinking so that we can be able to document that interactive process. Maybe it's, I need an outline of what to do when I'm opening a new patient record. Maybe it's, I need a visual reminder.
It's actually
definitely okay.
The issue is the clocking in and out on this ADP system.
Okay. But that can be as easy as, say, putting a sticky note on her monitor, putting a sticky note on her assignment for the day. That would be an easy thing to say, clock in and out. But to the extent that her forgetfulness is impacting patient care or impacting records, that's not something that we need to allow. That's not reasonable to say, oh, well, I forgot to ask the patient's weight, so I misadministered this med. That would not be okay. So I would encourage you to kind of talk through those issues with her, what can we do to help you remember to clock in? But it's not an option to just have you working off the clock. So what can we do to help you remember to clock in?
Okay. All right.
Does that make sense?
Oh, yes.
And then we just had a question come up on the chat box. It says, does job transfer to lesser paying job mean then does the employee pay rate or benefits, et cetera, stay the same, or does it change, drop within the job?
And that generally depends. However, if we have gone through an exhaustive interactive process and we cannot do anything to bring this person back to work in their same position, they are totally unable to do that job, and they tell us, yes, I can't do that job, but I can do this job. I can't do my nursing duties, but I can do tech duties. Then what we can do is move them into a tech position if that's what they're saying that they can do, and that's consistent. If we have a higher paying job that's more on scale that they can do, we need to look at that first. You know, the goal is transfer them to an equivalent vacant position. But there is guidance out there from the EEOC that says if we don't have an equivalent vacant position and we're transferring them to a lesser role, then it is okay to provide them with that offer. If they take it, then their pay changes and their benefits change just as any other person in that position would. Now, if we offer them a janitor position, but they're capable of doing considerably more, and we have that other vacant position, which is considerably more, it would be viewed as retaliatory to place them in the lowest paying role. Does that make sense?
I believe so.
Okay.
They're saying not giving them a choice.
Not giving them a choice to do the transfer. Well, if we have the information from them that they can't do their job, then one available option is leave. One available option is transfer to a vacant position for which they're qualified. So if we choose to transfer them to a vacant position for which they're qualified, and that is a lower paying position, and they do not believe that that is a position that they want and choose not to come, I would say, A, we need to be able to explain why we brought them into that position as opposed to granting them the leave and why it would be a hardship to give them the leave. But assuming we could explain that, then if that person turned down the role, at that point, ideally, the court would find fault with the employee's inability to engage in the interactive process or failure to engage in the interactive process. Now, is it a surefire winner? Not necessarily, because we've got those factual disputes about whether we should have provided the leave as a reasonable accommodation, whether that would present an undue hardship. So while it is up to the employer to come up with the ultimate accommodation at the end of the day, we still need to be able to factually explain and distinguish before a jury why we chose what we chose.
Do we have any other questions or comments?
It didn't go.
Okay, if we don't have any other questions or comments, feel free to indicate them on your evaluation, or you can send them on to Jennifer or myself, and I will make sure, if you send them to me, I will make sure that our presenter gets them, or you can send them right on to her. She has provided you with her contact information. That, you guys go, because I know you guys are very busy people. Oh, we have another one here that just popped up. It says, my organization doesn't qualify for FMLA. If leave is requested, what is the best practice?
I'm sorry, what was the question?
The organization does not qualify for FMLA leave. If FMLA leave is requested, what is the best practice?
If FMLA leave is requested and they do not qualify for FMLA because of the size of the organization or because they are not close enough in proximity to meet, say, the 75 employee requirement or the 50 employees in a 75-mile radius, then I would say your best practice is to explain to the employee that The employer does not qualify as an FMLA employer. However, if they require accommodation, we definitely have a process in place. Please let us know. Let them know what that process is. Provide it, and it may be a situation where we have to accommodate it from a disability perspective, even though the FMLA doesn't apply.
And if you're going to do that.
So that would be, is an accommodation process, it's just not called FMLA.
Exactly. It's not called FMLA, but the ADA applies to people with 15 or more employees. So as long as you're meeting that threshold, we need to proceed.
Okay. Thank you.
No problem.
Are there any other questions or comments? If not, we'll go ahead and let Jennifer get back to work, and I'll let you guys all get back to work. And if you, like I said, was saying before, if you have any other questions or comments, you can indicate them on your evaluation, or you can send them via email to either of us. And with that, we'll go ahead and end the webinar. And I did record it, and I will be posting it on our website along with the handouts. Okay?
Thank you.
So, thank you, and have a good day.
You too.